Assalamu alaikum and a very warm welcome to all participants. I'm Sabha Shah, Media Secretary of DLA, and it's my privilege to welcome you all to the 18th lecture of the DLA Trial Advocacy course. This course is a continuing effort to provide aspiring lawyers and young professionals with the knowledge, skills, and practical exposure required to excel in the field of trial advocacy. Today's lecture focuses on a highly significant and timely subject, defamation laws. We are honored to introduce our distinguished speaker, Mr. Zishan Manzoor. He is an additional district and session judge. With his extensive judicial experience and deep command of the law, Mr. Manzoor will guide us through the principles, procedures, and practical challenges surrounding defamation cases. His insights will broaden our understanding not only of the statutory framework but also of the courtroom realities that shape the application of these laws. We are truly privileged to have him with us today, and this session is expected to be an enlightening and impactful experience for everyone present. Now, let us warmly welcome our esteemed speaker, Mr. Zishan Manzoor. Sir, please start the lecture.
Thank you, ma'am. Assalamu alaikum, everyone. Ma'am, first I would like to know whether I'm sharing something to the students or practicing lawyers. Is
Sir,
it not?
there are both students and lawyers.
And is this not going to be an interactive one or just one-sided?
Sir, we will be asking the questions in the question answer session at the end of the lecture.
Okay. Interactive would have been much better. Anyways, because this is some an online sharing, so it would be a bit boring, no doubt, for everybody, I guess. Coming to the point. Students must be well aware because they are well acquainted with the theory, with the books. But there is always a gap between theory and practice in every jurisprudence, in every country, in every civilization. We always have gap between theory and practice, whether that be between the laws, that be in culture, that be in social norms, whatsoever. There always is some gap. And this is one of the reasons why you would have seen the English constitution is mostly unwritten, convention based. And perhaps this is one of the reasons because the compatibility they find is more in between the minimizing the gap between theory and practice with the passage of time, with the changing circumstances. Likewise, in Pakistan, we all have similar situation, whether that be in criminal laws, that be in civil jurisprudence, but there is some gap. So I would like to first just share that there are three major components. There are three major laws as far as defamation is concerned. Some sections we find in Pakistan Penal Code, and the major one being in 500 PPC. Pakistan Penal Code is synonymical PPC. So, and then there is a Prevention of Electronic Crime Act, that is PICA 2016, where we find one section, which is in terms of malicious code. And on the civil side, we have a complete law, a complete statute, that is Defamation Ordinance 2002. Defamation Ordinance itself has some touch on criminal side as well, but practically speaking, it is on the civil side. And when there is a law like Illegal Disposition Act 2005, you have a different law. And such like laws in ID law, that is in the illegal disposition, and then in defamation ordinance, you would find a mixture of criminal and civil litigation, which sounds some confusion at some point of time. However, when you go through the statute and when you go through its preamble, it's pretty clear where to move when you are going to touch civil line and when you are going to move on the criminal side. There always is a difference. The primary law, though, it is old law that that is Pakistan Penal Code have incorporated in 1860. Though we have certain amendment with passage of time, it's been more than 150 years since then. Yet we have deep-rooted traditional law in it, which actually focuses on the cultural norm that we adopted or we borrowed from England and then from India. What English did, we came into line with our own laws. If you would find in Pakistan Penal Code and then any other law that is prevalent, all laws that have been adopted by Pakistan Code in 1946, that have been codified in Pakistan Code. The chief law is the Pakistan Penal Code as the substantive law, and then the procedural law is CRPC, that is Criminal Procedure Code. As far as Pakistan Penal Code is concerned, you've got just one chapter, chapter 21, consisting of hardly 5 to 6 sections for defamation. That is primarily focused on defamation laws. 499 CRPPC actually defines defamation. When you bring it in juxtaposition with the civil definition, which is in Defamation Ordinance 2002, you would find certain similarity, yet there is some difference which actually would bring you to a difference between criminal and civil. When you go to, I think, when you first look into the PPC, that is purely criminal side, section 499 PPC, it defines defamation. If you have got books or if you have gadgets, if you've got your cell phones, the same must be before you. It is pretty clear. Whoever by words either spoken or intended to be read. Let me make it clear. A criminal offense consists of two basic ingredients you must be aware of. That is actus reus and mens rea. Means criminal act and criminal intent. Intent is the basic ingredient. The first ingredient of criminal offense. First, you intend to do something wrong and then you commit the wrong. If either of the ingredient is missing, the offense does not get to completion. Now coming to the same for defamation definition, again, it focuses on intention. This is criminal law. So this is basically focusing the basic principles of criminal jurisprudence. It says, whoever by words either spoken or intended to be read, or by sign or by visual representations. This is very, very liberal definition with a widely large scope. May it be spoken, may it be intended to be read, may it be by signs, by visual representation. The purpose is makes or publishes any imputation concerning any person. In simpler terms, either by words or by your intention or by your representation, you are actually intending to harm someone's reputation. That brings you into the scope of defamation. Naturally, there are some exceptions, like any harm that is caused by natural phenomena, by certain decision, by certain court or parliamentary decision. You have parliaments, they had House of Lords, that's the difference, but by any law that is legally justified, any act that is legally justified does not fall within defamation. So the exceptions are pretty clear in section 99 itself. Whenever an FIR is lodged, now section 500 PPC is the section which provides for punishment, and that is hardly 2 years, not more. All laws which relate to defamation in Pakistan are very soft in their inception. Soft in a sense, those are non-cog, whether that be in Pakistan Penal Code or that being Prevention of Electronic Crime Act 2016, whether that be PICA, whether that be PPC, or whether that be in defamation ordinance. Soft means no strict and no immediate action is taken. No FIR is being lodged in the first instance. Section 500 PPC is a non-cognizable offense. Likewise, malicious code, section 20 in PICA Act 2016, that is also non-cognizable. Likewise, in Defamation Ordinance 2002, it is again a non-cognizable. Then there's a difference between cognizable and non-cognizable. In a cognizable offense, police is at liberty to lodge FIR immediately. In a non-cog offense, you don't have an option for FIR in the first instance. Either you go for direct complaint or you for 155 CRPC proceedings. 155 CRPC proceedings means the police actually files a report before the concerned magistrate having territorial jurisdiction and places the material before the magistrate, who would then go through the complaint. Either he would direct for investigation or he would decline it. If he directs for investigation, then and then he can convert it into a COG, like directing for FIR under 156 sub 3 CRPC. That is the prerogative of the magistrate alone, not a sessions judge, not the High Court, not the Supreme Court. That is how you convert a non-COG into a COG. The other option is filing a direct complaint before the magistrate concerned. When you are going for defamation under Pakistan Penal Code, then you file a non-COG. The police officer files a non-COG report and proceeds, as I said, 155, the magistrates go through it, and if he deems fit, he actually directs for investigation or otherwise. But when there is no such provision of FIR, ultimately, like in defamation ordinance, you can't go for FIR. Then you go for direct complaint. In PICA, you go for a complaint. And then PICA also has the similar procedure of 155 and 154 PPC. So the major content, major law that came into actually bringing the composed law, that was Defamation Ordinance 2002, which consists of 16 sections. It's a very brief law. It is a very pretty easy and clear-cut preamble, which is actually the directive of any statute. Preamble leads you to the understanding where the particular law, particular act or statute actually goes to. Important sections: Section 4, Section 5, 8, 10, 12, and 15. Your questions after my discussion would actually be clearing your concepts. I don't know what's going in your mind at the moment, but I'm going to give you the brief. And when I answer your queries, hope I'll be able to. Then I think things will be more clear, but there should be some foundation which I'm going to place now. Defamation Ordinance 2002 has a similar definition. It defines in Section 3. It says any wrongful act or publication or circulation of a false statement. Remember, each and every ingredient of a section is a mandatory to complete the ingredient of the offense. Any single ingredient missing from it, from the given definition, would not lead the offense completion. So Section 3 defamation says any wrongful act or publication or circulation of a false statement or representation. Now, how? Made orally, that you call slander, or in writing or visual form, that you say libel, which injures the reputation of person. This is the important principle, which actually is intended to injure the reputation of person. In Pakistan Penal Code, there was intention, Herein, it's not intention. Herein, actually, the completion of act. So it says, which injures the reputation of a person or tends to lower him in reputation or reduce him to some ridicule or criticism or contempt or hatred, it would fall in defamation. Defamation is of two kinds. Everybody must be knowing, that is libel or slander. Libel when you make an oral defamation, slander when it is in writing or publication or circulation or whosoever. But another thing, how as far as the one of the principles is that even if that false representation or statement is communicated as a single person other than the person defamed. Suppose you are stating an allegation against A, then even if that allegation comes into knowledge of B alone, not C, D, E, F, even if a single person, it would come in definition of defamation. You need not to defame a person in a public of 100 people or 1,000 people. Even a single person would make it coming within ambit of defamation. This law provides for a presumption of damage, presumptuous damage. There are two kinds of damages in civil law. When you sue somebody for damages, for recovery, for damages, either in defamation or generally, there are two types of damages. One is general damage, the other is special damage. General damage is actually a rule of thumb. It is plainly the discretion of the judge and his understanding, of course, because discretion has to be used judiciously and not arbitrarily, keeping in view the circumstances, how he finds it, it's actually upon him. So Section 4 Defamation Ordinance provides for a presumption of damage, that if someone has brought a suit for defamation and that stands proved, judge need not ask the plaintiff or the person suing how and what sort of damages should be calculated. It is the responsibility of the judge to determine himself general damage, and that general damage has to be counted in terms of compensation. That is clear. For special damages, then he has to prove each and every count, not for general damages. Then Section 5 of the ordinance brings defenses. What defense you have against anybody's allegation? Clear cut, there are like that should be done in good faith. Achha. If you go through these defenses, these all are subjective. These all have to be proved. If anybody takes a defense, it's not merely taking a defense. It is to prove the defense. If I'm taking a defense that I had published such and such material against Mr. A on such and such date in good faith, I have to prove it. Yes, it was in good faith. Otherwise, I would be liable. So the burden of proof shifts on me. If I take the defense, the burden will shift on me. It is against the principles of prosecution. You may be aware, in criminal prosecution, like in PPC or in any criminal law, it is the prosecution or it is the complainant who has to prove his case. Burden never shifts, never. Except in certain situations, very, very deep situations, like prosecution has proved its all case, and then the accused takes a defense and is a statement under 342 CRPC, which generally is recorded at the end of the trial, though there is no embargo. It can be recorded at any stage of trial. Whenever any incriminating material comes before the court, it can be placed before the accused, and as many as times that the judge deems fit. But unfortunately, this is, as I said, there is gap between theory and practice. Unfortunately, it has been taken up in their mind by the judges that they record 342 only after closure of the prosecution side. Otherwise, there is no involvement. You can record as many times judge deems fit or the court deems fit. So coming back to defenses, then there is based on truth that there's some court decision, some parliamentary decision, or a privileged communication between officials, between lawyers and their clients. These are the defenses. And any just defense, any defense that can be through qualified privilege. For qualified privileges, you may refer Article 6 to Article 18 of the Kanun-e-Shahadat. Those are the qualified privileges. So any such privilege actually is a big defense against any defamation. Then, what is the procedural law? And the procedure is very important at the moment in this law, which is apparently it's a procedure, but it is a part of substantive law. The first one is notice of action, that is Section 8 of the Defamatory Ordinance. It says you cannot take any action, you cannot bring any suit against someone who has caused defamation against you until and unless you have given him 2 months after the date of publication or date of the defamation having taken place. If you have not given him, you have to give him 2 months notice, and within 2 months of the date of knowledge, you have to give him the notice, and that notice should provide him 14 days at least to bring apology or to submit his reply. You may not institute any list, any suit against him until and unless you have given him 14 days to correct him, right? And this 14 days notice should come within 2 months of publication. This is Section 8. Any violation of Section 8 bring the suit in rejection. Then you have got Section 12, that is limitation. Limitation says 6 months from the date of knowledge of publication. 6 months. If I am defamed, if I am the victim, someone has caused me, my reputation, has brought my reputation as a stake, then I come to know the same on 1st October 2025. Within 6 months from that date, if I intend for any suit, I have got only 6 months limitation. And those 6 months include those 2 months of notice. Primarily, Section 10 says Civil Procedure Code and Kanun-e-Shahadat. These apply to the proceedings of defamation ordinance. Like, if I'm not bringing a suit within 6 months, I'm bringing the suit after 6 months, maybe 6 months, 10 days, 6 months, 18 days, 7 months, 8 months, 9 months. That suit cannot stand law. That would be barred by rejection of the plan under Section 7, Rule 11D of the Civil Procedure Code. Likewise, 710 applies. Likewise, all the procedure incorporated in Civil Procedure Code applies the same. Similarly, Kanun-e-Shahadat applies. Kanun-e-Shahadat is the law of evidence. It is both substantial and procedural. It's a combo of the two. At times it becomes procedural, at times it becomes substantive. So the remedy which is available under Section 9 of the ordinance, it's if the case stands proved against the defendant, then the court can direct for apology, direct him to tender apology in a similar fashion. Similar fashion means if he has got the defamatory material published in some newspapers, Dawn or any Urdu newspaper, or the News or Jung or any Sindhi newspaper or any newspaper, in the same newspaper, the apology should be tendered. Number one. Number two, he may be penalized for damages at the minimum rate of 50,000 rupees. That would be general damage. And then special damages can also be awarded as per circumstances. Now, for general damages, that is rule of thumb. Rule of thumb means the court has to see the capacity. See two things: the capacity of the person who has caused the damage, who has spread the defamatory material, disseminated defamatory material, and the reputation, the loss of the reputation, how much loss it caused, whose reputation was caused, whether it was a prime figure, a leading figure, he suffered a loss at political stature or a business stature, or in his clan, his tribe. These two things would be seen. If you have ever appeared before family courts and contested maintenance suits, you must be aware the primary yardstick for the judge is always to see the capacity of the defendant, how much he can pay. Similar is the position in defamatory ordinance. These are actually the key points, and I'm very much hopeful that I can only make it all clear in response to your queries, because it becomes quite, this is perhaps this is the first time that I'm sharing something on one-sidedly. So I don't know what's going in all your minds or whether I have been able to give the brief. So please, I'm anxious to welcome your queries. Thank you.
Okay, sir, I will be asking the questions from the participants.
Yeah.
Sir, there is a question. In the age of social media, can traditional defamation laws still be effective?
Defamation laws are primarily for social media, I think. PICA and defamatory laws. Publication and circulation. Publication doesn't mean only newspapers, or it may be electronic. Like circulation is through social media web channels. You circulate things, you circulate defamatory materials through videos, through voice contents, and through your WhatsApp, through YouTube, through Insta. Any channel can be used. So circulation is a wide definition. So these laws are very much applicable. And not only, one thing I would add, not only defamatory laws, but also electronic crimes laws. And one evidence to that is inclusion of section 20 in PICA 2016, which again is is focused on malicious code, and is a similar definition is in defamation ordinance and in Pakistan Penal Code. And you are well aware that PICA 2016 is primarily focused on social media channels. Hope the question is answered.
Sir, the next question is, should truth always be a complete defense, even if it damages someone's reputation?
Yeah, it can be. But the primary condition is you have to prove good faith attached to it. Truth, not in isolation, but must be attached to your intention of good faith, that you did not intend it to harm otherwise.
Okay, sir, there is a question from Muhammad Atif. He's asking, what is the punishment for defamation, and is it a tort law or a criminal category?
I already explained this. There are three primary laws. Chapter 21 in Pakistan Penal Code, if you are suing somebody through Defamation Ordinance 2002 and you are choosing tort law, that is in terms of defamation ordinance, then it is tort. Like, then the remedy is damages and attendance of apology. This is tort law. As far as criminal law, then you have Pakistan Penal Code and PICA 2016. If the material that has been circulated is through social media channels, through electronic media, then PICA 2016 would attract, section 20 would attract. You would go for the FIR or the direct complaint in that law. If the material is in ordinary manner, like publication in newspapers and like defaming some person orally in presence of some people, then Pakistan Penal Code would attract, that is criminal law. So you have got both remedies. It is up to you to choose which one.
Thank you, sir. Next question is, can without giving notice of 14 days, a suit can be filed?
No. Notice is mandatory. Otherwise, the plan shall be rejected under 711 CPC.
The next question is, what about journalists? They publish and spread false statement without any authentication. Shall they be liable for punishment?
Sure, you can bring them to the court, but the burden onus to prove would be on your shoulders. And this is what you must have watched in video in movies, in Indian movies mostly, especially old movies. Politicians used to sue journalists for defamatory material published against them. You can, and onus to prove would be on yours.
Sir, should reconciliation or apology be given more weight in defamation cases?
That is the first requirement. Section 8, the purpose of notice of action is actually for tendering of apology. The notice is served only for the primary person that the other person is asked to tender his apology. If the apology is tendered, it prevents the suit or the list. That is the first requirement. And even if the suit is placed before the court and the entire trial is proceeded with, at the culmination of trial, if the case is proved, the first remedy is their apology. In a similar fashion, like if you had published some defamatory material in some newspaper, the apology should be tendered in the same newspaper.
The next question is, what is difference between 500 ppc in criminal nature and civil suit for defamation in civil nature?
It's the same principle as the principle of civil law and criminal law. In criminal law, the burden entirely is shouldered upon the one who initiates the action, like the complainant. And quality of evidence does not matter much. Quantity of evidence actually matters. In civil law, that is preponderance. So in PPC, there are a number of differences. In PPC, you have got sentence, punishment. You may be the defaulter may be sent to jail. But in civil law, there is no room for jail or sentencing like that. In PPC, it hardly gives you a room for compensation. But in civil law, it gives you room for compensation. In PPC, there is no compensation. There's only a sentence. Like, for instance, let me give you a small example. If there's a case of dishonorment of check, you have got two remedies. One is to knock the court under 489 FPPC, you will lodge an FIR under 489 FPPC. By lodging of FIR, you jump into criminal proceedings. In criminal proceeding, you will not get the money back. You will not get the dishonored money back. The only remedy available in criminal law is sending the person to jail. However, if you want to recover your money, the money that was dishonored through the check, then you have to file either recovery suit in the civil proceedings or a summary suit before the district judge for the against the negotiable instrument. So civil and criminal, these are two separate remedies. Similar is the case in defamation laws. In PPC and PICA, there is no remedy of compensation. You can only send the person to jail. However, in defamation ordinance, when you jump into civil proceedings and you prove the case, then you can be compensated for the damages.
Sir, do defamation laws discourage healthy debate in politics and media?
That is subjective. Politics has become so dirty that it hardly affects. However, media has to be a bit sensible because that brings things on record and that is recorded. So it affects for media, not for politicians, because you may find several instances at the end of the day, they say it was just a political statement and it can be ignored.
Sir, why is protecting reputation considered as important as protecting freedom of speech?
Sorry, would you repeat it, please?
Yes, sir. Why is protecting reputation considered as important as protecting freedom of speech?
These are two converse ideas. Freedom of speech is not absolute, and that it goes back to the Nelson Mandela's times. It was like, and back in 2005, 2006, when there was burning of Holy Quran in different countries, and some hate speech was conveyed by the Swiss rulers and French rulers. Those times, um, it was brought on surface that freedom is not of a speech is not absolute. So reputation is directly linked with freedom of speech. Freedom of speech has to be reserved, but like you can't express everything against everybody only in the manner it pleases you. If you transgress some limits, every society prescribes limits. If you transgress some limits, then you bring in the radar. You bring yourself in the radar, and when you are in the radar, then you have to pay the price.
Sir,
It's
next
clear.
question is, how do defamation laws affect press freedom in Pakistan, and what reforms are necessary to strike a fair balance between journalistic accountability and freedom of the press?
Well, defamation laws are directly linked to journalism and social media. They have directly proportion with those channels. As far as how these influence them and how these are helpful or not helpful is concerned, it varies. Again, it is subjective because defamation laws actually prescribes a social code that has to be abided by. As far as reforms are concerned, I think the laws that have been brought in place before us in Pakistan are not so comprehensive. Number of changes ought to have been invited in this. The problem is that we basically commit intellectual theft. It is hardly that we find a complete code from our own legislators. That is ironical, but it is so. Defamatory laws are not given widespread circulation even. It is the same case as you have the laws relating to harassment of women at workplace. That is a complete law. Harassment of women at workplace encoded in 2010. But how many departments or how many organizations or how many offices who follow this? Only because of lack of awareness and because of lack of implementation. Implementation is the key. Even if you bring this law in field and enforce, not for 100%, even for 50%, I think you will feel the difference.
Sir, the question is, the typical defamatory words deemed defamatory can give rise to legal suits?
Yeah, if those defamatory words are circulated to any person other than the person defamed.
Sir, how can courts decide whether a statement is fair criticism or defamation? Kindly explain it.
That depends upon the evidence. It is upon the plaintiff who brings the list, brings the suit before the court. He has to prove, or in the criminal law, it is upon the complainant. He has to prove how that material actually injured him, his reputation. For instance, for instance, you are a CEO of a leading firm, and somebody has actually brought on circulated and misinformation against you, involving you in some scandal, in some corruption, or which may be true or which may not be true. And that injures your reputation to the extent that you fail to obtain tenders which you would have done otherwise. If such would not have been the situation, you might have succeeded in getting tenders of billions and millions, but you lost it. You lost the reputation. For instance, or likewise, if you are running a food industry and I'm sharing some material on some content on social media, trying to injure your reputation by stating some allegations that the food you served by you either is not prepared in hygienic conditions or have some material that is hazardous to human health. And my such circulation results in drop of your sale, you can sue me for damages for defamation.
Sir, the burden of proof is on which party in defamation?
In criminal law, it is upon the complainant only, primarily. In civil law, it shifts. If the plaintiff has proved his case and the defendant takes a plea in his defense, because in civil law and criminal law, it is only the evidence of complainant side that is to be recorded. In civil law, you have got plaintiff side and then defendant side. If the plaintiff side has completed his evidence and has proven its case, and the defendant side has taken a defense, if they are taking a defense, the moment you take a defense, burden shifts on you. So it's change of responsibilities and change of onus to prove it in the civil law.
Sir, there is another question. What factors should courts consider while deciding the amount of damages in defamation cases?
The stake of the person defamed. Like I earlier cited two examples. If you are running a food industry or if you are CEO of a of any uh, you know audit firm, so it depends how much loss you have actually you have incurred. It depends upon loss, and you have to prove because you have sued me. I'm the defendant, your plaintiff. You have sued me. You have to prove two things: that defamation was caused three things. Defamation was caused, number one. Number two, defamation was caused by the defendant. Number three, what loss you suffered. So after you have proved these three, the suit stands proved. And the last point, what loss has incurred, would actually lead the judge to decide the damages. That would be directly proportional to the loss.
Sir, there's a question. Are defamation laws mostly used by the powerful to silence their opponents?
Mostly, I agree. I agree. Hardly we find any laws that are any suits or any cases which are actually genuine. Those may be genuine, but those are encrypted with malice, mostly. I agree with your assertion.
Sir, can traditional courts handle online defamation cases quickly and effectively?
Yeah, it's not very difficult. The only hindrance, the only hitch we are facing in courts, we judges, I have decided a number of cases even. The only hitch we are facing is that we don't get convincing, cogent material on record. For online defamation, FIA authorities are actually engaged. Any FIR lodged on PICA is investigated by the FIA. And FIAs don't take interest. Their only interest is to, bring the person in the neck of the trial only. Once the trial is proved, they hardly take it. So they are facing problems from the prosecution agency, from the FIA, from the police. If they come to bring all the material fairly, transparently, it's no issue. These are not difficult cases. These are not murder cases. These are very, very easy and focused cases. There's a defamatory material is published, or material is circulated through channel, everything is available. Your gadgets can be sent for forensics. We have got so much technology today. And then we have known dates on one material, on what date this and this material was dispatched or published or circulated, through what media, through what channel. Everything is clear. These are crystal clear cases. It's not difficult to deal with and conclude these cases in timely manner. It's not difficult. It's not like ordinary cases.
Sir, the last question is, when civil damages are available, is
Yeah.
criminal defamation imprisonment still necessary?
Not necessary, but it's your choice. You can go with both type of litigation simultaneously. You can choose one of the litigations. It's all the choice of the person who's defamed. There is no embargo. There is no compulsion.
Okay, sir. ये भी last question है. Against
Yeah.
whom suit be filed when we don't know the offender who spread rumors and it causing damage like losing sales?
Well, I would suggest that in these sort of situations, you can go for lodgement of FIR under PICA 2016, not a suit. You cannot file a suit against unknown person or a dead person, because Order 8 CPC requires you to provide complete details of the defendant, his name, address, parentage. So if you don't have these, you can't bring a list. You can't bring a list against either unknown person or against a dead person. But you can bring an action or an FIR against unknown person, because that would be then the responsibility of the prosecution agency to find out who actually did the damage.
Okay, sir. Thank you so much, sir. The question
Thank you
has
so much.
already answered, and for sharing your valuable knowledge and practical insights with us
So
today on
grateful.
behalf of
Thank you.
Daily.
And I apologize if it didn't go smooth because this was
No, no,
not
sir,
the
it's
manner
okay.
actually usually do. So it was
No,
something
sir,
new
the
for me.
session is very knowledgeable and it will go smooth. And on behalf of DLA, we deeply appreciate your time and contribution. A special thanks to all our participants for keen attention and thoughtful questions. With this, we conclude our lecture.
I
Okay,
thank
sir,
all
love
and
it.
uh, best of luck, everybody, and welcome to
Thank
the
you, sir.
field.
Thank you so much, sir.
Thank you so much. Thank you so much. Allah
Allah Hafiz.
Allah Hafiz.